The latest news, national issues, the political scene, and conversations with prominent personalities. All these firsthand at the forefront. Two Filipino judges have sat as International Criminal Court magistrates. The first one was former Senator Miriam Defensor-Santiago. The second was Judge Raul Pangalangan, who presided over cases involving some of the most notorious figures accused of crimes against humanity. His experience in handling politically sensitive trials provide valuable insights into the complexities of international justice. With the arrest of former President Rodrigo Duterte, questions about ICC's procedures, jurisdiction, and judicial independence have become topics of heated debates. How does Judge Pangalangan view the significance of FPRRD's case? And what is the broader implication of the ICC's role in upholding accountability? Joining us this morning via Zoom, live from Washington, D.C., is a former ICC judge and now a member of the Permanent Court of Arbitration in The Hague, Judge Raul Pangalangan. Good morning, Judge Raul.
Hello. Well, good evening from Washington, D.C., and good morning to you, Karen.
I have to say, Judge Raul, this makes me very nostalgic to interview you because you were our dean when I was a student at UP Law. And years later, when I was teaching in UP Law, Attorney Chrissy Conti was my student, and now she's the assistant counsel to the ICC. So it's just, it really makes me nostalgic to be now interviewing you, and then a few months back, I also interviewed Attorney Chrissy Conti.
Well, Karen, now it's your turn to make me recite.
Yes, that's true. So we'll start first because a lot of people are very interested about you personally. You were a member of the judge in the ICC, but before you, Miriam Defensor-Santiago was an ICC judge from 2011 to 2014, and she resigned back then because of cancer. Did she refer you to the ICC, or is there any, well, correct us if there's anything inaccurate in the timeline.
Well, she was my former professor, actually. Miriam Defensor-Santiago was my professor at the UP College of Law. She was elected to the ICC as a judge. But Karen, she never took her oath as a judge. She never served as a judge at the ICC because she continued to sit as a senator of the Philippines. So, well, I'm actually the first Filipino judge to sit on the bench.
Okay, so that's something that we should correct, that you are the first and only Filipino so far to be a judge in the ICC. Were you able to confer with Senator Miriam Santiago when it comes to your role as ICC judge? Did she give you any tips before you took your position?
Well, actually, Karen, I helped her in her campaign because you see, to become an ICC judge, one has to win the votes of the members of the Assembly of States Parties. That's all the member states of the ICC. And when my professor Miriam Santiago was nominated, I actually helped in her campaign. I helped answer there's actually an official questionnaire issued to all to the nominees, and I helped answer I would like to say I answered the most difficult questions in that questionnaire in behalf of Senator Santiago.
So it's not a simple matter of being referred. It's really a competitive process because you have to be elected and you have to undergo that series of also, I suppose it's almost like a test. You have to answer questions.
Yes.
And I think for everyone, yes, go ahead, Judge Raul.
Oh, it is a difficult process, Karen. There is some sort of the global equivalent of a Judicial and Bar Council. They call it the Advisory Council on Judicial Nominations. It's quite a distinguished panel. They grill the nominees. They ask the tough questions, and after that they submit a report. an evaluation of the candidates. They give it, they circulate that to all the member states. I had to meet with the most of the national delegations in various places, and then there's the election of judges by all the member states of the ICC.
Okay, so it sounds like it really is a rigorous process. So we can expect all the current ICC judges to be very competent and of high caliber.
Oh yes, for sure. You see, Karen, in the Rome Statute, there are two sets of judges: those who come from the who are career judges and career prosecutors, and on the other there are those who are experts in international law, diplomats. Well, they call it the jurists in other countries. But both sets are vetted by this judicial and by this advisory council on judicial nominations and elected by the member states. So yes, before one gets there, one gets vetted at so many levels by the member states.
And I think for those of us who are listening, they should also know that you are the first professor in Harvard Law School to be Filipino. Is that correct? Or one of the few?
That is correct.
Yeah.
I was visiting faculty. Yes, I have taught at Harvard Law School. I've been invited twice to teach there. I taught, the last time around, I taught international law, which is the subject I teach at UP, and which is the expertise that I brought to the ICC.
And Judge Raul, do you need to be a lawyer in order to be an ICC judge?
The rule is that the nominee, we're now talking about the qualifications, the nominee must be eligible to practice in one's own jurisdiction. Now, different states will have different rules on eligibility to practice, because in the Philippines, we follow the US practice, where there is a bar exam. In other countries, they have different licensing processes, but the ICC respects the competence of every member state to license its own lawyers, and so I think that's the safest way to answer your question.
Mm-hmm. And in terms of licensing lawyers, are there other qualifications that lawyers have to have in order to be licensed to practice or appear before the ICC?
Okay. Now, Karen, that's an entirely different set of rules, because we were first talking about the rules for eligibility for judges.
Yes.
And you're now talking about eligibility to appear before the court. Let me start with the judges. There's the requirement, of course, for competence in the field. And the other, and they're very strict about this, integrity and independence. So there's the ethical dimension of those requirements. And by the way, those are very strictly applied at the ICC. Now, about the lawyers appearing before us. That's the thing, Karen. Now, of course, just like in the Philippines, the prosecutors, we call it the OTP in the ICC, the Office of the Prosecutor. These are career prosecutors hired by the ICC. In the last case that I heard, it was a QC, a British Queen's Counsel, who appeared before us. But the prosecutorial service are full-time lawyers engaged as prosecutors by the ICC. Now, it's a completely separate matter for what we call the defense bar, the lawyers for the accused. The court has its own accreditation process. I have seen lots of news articles about I think 5 Filipinos accredited to practice before the court. I'm not familiar, Karen, with the details of how they qualify, but there is also a similar process of accreditation for the defense bar.
Okay.
Now, and one thing I'd like to add, Karen, is that in the courtroom in the ICC, there is actually a third team of lawyers. That is the representative for the victims. So that's quite unique, different from the Philippines. the victim's counsel is entitled to present his own evidence, is entitled to cross-examine witnesses, to make filings and submissions before the court. Well, those counsel also have to be accredited before the court. So there's a process of winnowing out lawyers to ensure only the highest quality of service before the court.
Do they have a process similar to a bar exam? Because here in the Philippines, you have to take a Philippine bar exam in order to be licensed to practice law here and appear in the courts in the Philippines. And then in the United States, they have a similar rule for different states, like New York bar exam, California bar exam. Is there an exam for lawyers in the ICC?
Well, Karen, I'm absolutely sure that they don't have anything like the Philippine bar exam. You know, the quasi-torture process of preparing for an unpredictable exam. I don't know whether there is an exam they have to sit for. You know, the judges don't get involved in these things, Karen.
Judge Raul, are ICC judges required to live in Netherlands during their whole term? And how long is the term of a judge?
Yes. You know, Karen, short answer, yes. We are required to stay. There is a formula under the rules, but basically, to live in an area where we make ourselves available to serve in the court at any time. That is, I have forgotten the formula. But as a practical matter, Karen, yes, the judges live in have their home in the Netherlands. It is, the court's docket is quite busy. I think it is impossible for a judge just to fly in. Because, Karen, you see, like in the other court in The Hague, the ICJ, International Court of Justice, they have such a thing as the judge ad hoc, judges who sit only in one specific case. And I think those judges do get to stay in The Hague if the cases are busy, but are actually not required to be there full-time. Compare that to, in the former Yugoslavia tribunal, they had the judge ad litem. Again, by the nature of their work, the judges ad litem are still required to live in The Hague. In the other international tribunals, the Law of the Sea Tribunal in Hamburg, only the president is required to live in Hamburg.
And based on the presence of the judges, the term is how long?
The term is a single non-renewable term of 9 years.
9 years.
That is the formula. Okay. And so in my case, it was by Professor Miriam Defensor-Santiago who was elected, and when, exactly as you said, Karen, she resigned her seat, never had the chance to serve. She resigned. It was effective after 3 years, so I took over the remaining 6 years. That's what I served. But Karen, I must emphasize that I had to be elected all over again. There were other nominees for the position. One was a retired Chief Justice and the other was a justice like an Attorney General somewhere in the Middle East, and myself.
Wow!
So I had to campaign for that seat, and well, unfortunately, I won.
Well, it makes us proud as Filipinos to have you being elected for that post. But 9 years is such a commitment, like for any person to suddenly have to relocate the whole family to Netherlands. Based on the past cases handled by the ICC, it seems that on average, it can take about 10 years from the time a case is heard up until the conviction or acquittal or the decision. So if there is a change in the composition of the judges, how does that affect the trial of a case?
That is a good question, Karen. The ICC practice is very different from Philippine practice. I'm speaking about the trial chamber. I was president of my own trial chamber. I was eventually elected president of the trial division. There are 3 divisions in the ICC: pre-trial, trial, and appeals. I became president of the trial division. Karen, the rule is that the same set of judges, the same triers of fact, will sit from beginning to end. And that is why if a case is not yet finished by the time the judge's term is finished, then the court actually extends the term of the judge, which happened to me.
Oh, wow.
Because the principle is that the trier of fact, to make a finding of fact, the requirement is that it has to be consistent from beginning to end. You cannot change the composition of the tribunal and transfer the responsibility to a new judge who was not present during the presentation of evidence.
Okay.
I actually, when I told my colleagues about the Philippine practice, where the presentation of evidence is done under one judge, and then that fellow is either promoted or retires, and a new judge takes over and writes the decision, and they were actually shocked. And I can perfectly understand. Because, and by the way, because especially in the continental system where a judge is the trier of fact, the determination, the findings of fact have to be made by just one person. I think, Karen, now I'm being a bit philosophical here. You know, it is a recognition that making a finding of fact entails a lot of subjectivity. And in the ICC and in other jurisdictions, that subjectivity is reposed on three people, so they can actually counter-check one another. If one judge is rather lenient and the other is rather strict, then I suppose you find a point of equilibrium. But the most important is that it should be consistent from beginning to end. And I think Pinoys sort of assume that facts are objective and that there is no subjectivity involved. And I think the continental system is a bit more frank about it.
Meaning
And
they
installs-
recognize the reality.
Yeah, and installs checks and balances upon that subjectivity. Of course, in the common law, they just have a jury.
Yes.
So a jury of one's peers and laymen, a jury of laymen. And again, the acceptance of the reality that a finding of fact depends upon
The
human
appreciation,
judgment of
yeah.
what is, the accrued knowledge based on a lifetime of experiences.
Yes.
Anyway, sorry, Karen, if I
No, it's
digress
okay.
into all
But this is super
philosophical-
valuable for us because a lot of the analysis that goes into how the case of former President Duterte should be handled comes from our own understanding of Philippine laws. And mostly that's the analogy that people take when they're saying that, is it appropriate to do this or that? So when it comes to the ICC, something that stood out to me were the composition of the judges. It's all female. How did that happen? Are the judges for a particular case selected or is it by raffle?
Short answer, no raffle. It is, they are handpicked by the president of the court. And that is a power that is reposed in the president by the charter. Now, the president, well, okay. To start with, Karen, there are three divisions of the court. There are 18 judges, and we are divided into three divisions: pre-trial, trial, and appeals. Appeals will always have 5, and they always sit plenary. We call it en banc in the Philippines, plenary in appeals. For pre-trial and trial, we always sit in chambers of 3 judges. Okay, so if your question, Karen, is how does the president choose among them? There are so many different factors. To start with, Karen, we are 18 judges, and every 3 years, a new set of 6 judges will be elected. So there are overlapping terms, and therefore there will be seniority. And as judges are appointed, they are assigned to different chambers, to different divisions. my first division was the pretrial, and then I assigned to the trial. I was asked to sit on the appeals, but I declined because I had a trial that I wanted to finish, based on the principle that I mentioned to you earlier, that if you start the trial, you have to finish it. Now, I guess the president will have many factors to consider, Karen. I guess, first and foremost, the workload.
The workload, okay.
If somebody's overloaded, you get someone like get one of the newer ones to take on the work. There is the very important, Karen, the language. The official languages of the court are French and English, but you will notice that there are some panels who are predominantly French-speaking, panels which are predominantly English-speaking. Not surprisingly, this Pinoy was always assigned to the predominantly English-speaking panels. As you notice from from the proceedings so far, the presiding judge from Romania, preferred to speak in French, and there is an interpreter.
Do you think there was any consideration for why all females were selected specifically in the case of former President Duterte?
I don't think so. I will not venture that far, Karen. This is not, by the way, this is not the first time that an all-women tribunal sat in a case. In fact, I recall, I would say about 8 years ago, observers noticed that it was all three were women, and they rendered the case on sexual offenses, and people found it rather symbolic. Mm-hmm. But I don't think that was the intention. So if the speculation is three women judges were assigned to sit over a case of an openly misogynist person, well, I don't think that was deliberate. Okay, so you said it.
I was trying to stop myself from mentioning that, but I was wondering if that was taken into consideration. Like
I doubt it. I think in order to be fair to the accused, especially in this situation, I don't think that would be part of a deliberate design. And by the way, when I used the words I used just now, I don't think there's any. I don't think even the accused will deny the characterization. But
yes,
anyway.
yes. I think that's, as you would say in law, res ipsa loquitur. It is part of a lot of his speeches, the misogynistic remark. So I was wondering if that was factored in when they chose all female judges to be the judges for the case of former President Duterte. Going back to your experience.
Karen, also, thank you for citing the Latin terms for it. Again, I noticed that, again, in popular and legal discourse in the Philippines, we do love Latin words. Anyway.
And going back to your experience, what was it like handling high-profile cases like Al Mahdi and Ongwen?
Yes, these are cases that were the subject of intense public attention. They were covered by heavily covered by media. But Karen, again, I will say that in contrast to Philippine courts and Philippine judges, at the ICC, the tradition is that we should insulate ourselves from popular and populist pressures. I think, and properly so. Mm-hmm. And we are so careful about that. When I was a judge, actually, and I sat in the Ongawen case, which is about a Ugandan rebel leader who would kidnap boys and girls. The boys become child soldiers, and the girls become forced wives. Some of them were raped. And I recall I tried to avoid, how should I say this, watching any show which might deal with the case. Mm. And when my wife and I were about to watch this wonderful Broadway show, The Book of Mormon. I don't know if you've
Yes,
seen
I
that.
saw that. Yeah,
Karen.
that's very funny, that musical.
Yeah.
Yeah.
It was funny and wild, but you know, the core narrative is that this white guy from the U.S. went as a missionary, as a Mormon missionary to Africa. He was actually kidnapped by a rebel leader. So I told myself, you know, had I known that this light-hearted story, by the way, very well done, very well written,
So you would have,
resembled the case.
yeah,
I might have
you would have
from watching
not
it.
watched it in that case. You were that strict in terms of protecting your perception. You've handled.
Yes, in fact, Karen, I can
Yes.
even tell you one time I mentioned, we were just a conversation among judges. I said, you know, have you seen the criticisms on the court coming from a certain law journal? And I recall someone said, are we even supposed to read those things? And, which struck me because as a law professor, I read anything.
Yeah.
And I'm interested in what the law reviews say about decisions. I want to find out what mistakes they find in the reasoning. But apparently, again, in the continental law tradition, the idea is that the judge must be able to maintain the highest level of neutrality on a certain case.
And Judge Raul, you've handled other cases involving crimes against humanity. How would you compare the former President Duterte's case versus other crimes against humanity cases? But before you answer that question, we'll have to take a short break. At the Forefront, we'll be right back. Welcome back at the Forefront. Judge Raul, you've handled other cases involving crimes against humanity. How would you compare the case against former President Duterte as a crime against humanity?
You know, typically crimes against humanity and war crimes are committed, well, in the context of armed conflict. In contrast, the killings in the war on drugs were committed in peacetime, and I think that is the fundamental distinction. As you can imagine, if these are wartime offenses, number one, the range of the victims is much higher. In the last case that I handled, we had roughly 4,000 victims. But that is because it was a wartime crime. Now, so you're a lawyer, and Attorney Karen, you can also imagine that the range of legal issues we dealt with in those cases were different. Like, for instance, if we speak of, we call it the nexus to an armed conflict, should the crime have been committed in the heat of battle, you know, in the theater of war, or is it punishable if the crime was committed after victory in we call it the ratissage, the cleanup operation? So, you know, stuff like that. Those are the legal distinctions.
And I suppose, Judge Raul, for laymen, it's hard to sometimes comprehend because if you don't have that legal background, what you try to look at would be the obvious, like, is this person connected to committing the crime? And in this case, former President Duterte is charged as an indirect co-perpetrator. And when we say under crimes against humanity, when we look at the factors, which is systematic and widespread killings, when we saw the case and when the charges were read also in the initial hearing held so far in the ICC, it mentions 43 deaths in 10 years. So that would average around roughly 4 deaths per year if you want to do just like a rough average. And DILG Secretary John Vic Remulla quoted 30,000 deaths as linked to former President Duterte's anti-drug war. So I suppose people are wondering, if that is the case, then why is it not an allegation in the case filed before the ICC? And does this really rise to the level of crimes against humanity when you compare other cases like al-Bashir of Sudan with the crimes committed in Darfur?
Well, I can imagine the point that you're trying to make, Karen. The crime of al-Bashir, among others, was genocide. And
Yes.
genocide, of course, will entail violence at a large scale. It's called, the name is mass atrocity. It's a mass atrocity crime. But let me put it this way. First, the rules of the ICC say that the crime of murder as a crime against humanity is not limited by numbers. In other words, it's not as if it's not an ICC matter if it's lower than 10, or you don't have to peg a cut off number. Let's face it, the principle is that in the preamble of the Rome Statute, it deals with the most serious crimes of concern to humanity as a whole. And if you look at the gruesome killings in the war on drugs, I think it's reasonable to say that, one death is one death too many. I mean, we don't draw the threshold, the bright line distinction at any point. Human life is human life, and the court cannot ignore, cannot pay attention to some murders, but not to others. But the other related question to that, Karen, is that the wording of the warrant of arrest does not preclude findings on other deaths. In other words, the warrant of arrest was issued upon the specific deaths identified in that warrant, and the prosecutor may add charges in the future. That is a separate process. That is a separate long debate, and we call it the recharacterization of charges. At what stage it can be done, how drastically can the change be, can it be done in pretrial, is it done in trial? That's a longer debate. I think
That deserves
lawyers would love that debate, but for now we can, I just want to identify those two issues.
Okay.
The numbers will not make it any less a crime against humanity, because it pales in comparison to other worse moments in the world today.
Okay.
The fact is, it is bad. And I think by any standard, the range of killings that we have seen in the war on drugs rises to the level of a crime against humanity.
Judge Raul, is it the first time that a case involving an allegation of crimes against humanity involves a law enforcement operation? There are other anti-drug campaigns in countries like Mexico and Colombia, for example, that have resulted in thousands of deaths as well. Do you think that this type of case would then set a precedent for other cases in other countries to be filed as well?
Well, I certainly hope that it should set a precedent in that direction, Attorney Karen. But if I may add, it is not the first time that the court deals with crimes against humanity which are committed outside the context of armed conflict, because we have had several cases on post-election violence, and that is, in fact, the typical case that the ICC had in the early days, when someone runs for office and then loses, and then basically encourages like ethnic violence, so that a war of hate between ethnic groups ensues, all in order to overturn an election. So that is committed not exactly in the context of the usual armed conflict between rebels and a government, but between civilian groups, basically shooting one another.
Okay.
So I would really, in fact, hesitate, Attorney Karen, to characterize the problem here as one of law enforcement operations. To start with, many of the operations were done by vigilantes, by hit squads, which are not officially a member of our uniformed police, and if it was done by the uniformed police, they were certainly in violation of our own rules, and it is difficult to I hesitate to characterize them as legitimate peacekeeping operations.
Okay. And the first confirmation hearing is set for September 2025 at the pretrial chamber. Is this the forum where grounds to challenge one, due process or the validity of the arrest, is this a forum where that can be raised?
That is correct, Karen. In the normal course of things, the lawyers will wait for that moment. I imagine, based on the announcements, I think the lawyers might try to file something ahead of that. But yes, the confirmation hearing is the moment when the accused is asked to plead guilty or not guilty to the charges, and then it is then also that that his counsel will raise objections to the jurisdiction or admissibility of the case, and perhaps, as they have announced, ask for provisional release.
Okay, and for me as a Filipino lawyer, it looks very different from what we're used to in criminal proceedings here, because we usually have here a preliminary investigation involving the prosecutor, but the accused would have the opportunity to appear there, wherein there would be a determination if a case should be filed against him or her. But in this case, when you go to the pretrial chamber, it's already the accused or the suspect at that point that would plead guilty or not guilty. So the difference there, does this affect in any sense the ability of the accused to have any remedy? So for example, there have been questions on the validity of the arrest. Is this an opportunity for the case to be dismissed at that point?
Well, I'm so glad, Attorney Karen, that you raised all these issues, because in fact, early on, as I said in my lecture at UP, it's quite difficult to explain the ICC here in the Philippines because we assume that it should be the same. The ICC rules should be the same as Philippine rules, and they're not. So you're absolutely correct. The first distinction, very important, is what you identified already, Attorney Karen. For us, the prosecutor does the preliminary investigation, finds probable cause, he files the charges, we call it the information in the Philippines, and it is only then that the warrant of arrest is issued. In the ICC, the warrant of arrest is issued, and then the charges are filed before the court. Karen, just to show you the larger debates in the court, we call it the filing of the information in the Philippines. In other countries, they call it the filing of the indictment. In the ICC, it's called the DCC, the document containing the charges. You know, the most neutral possible term to describe, well, the document containing the charges. And now, if you raised the issue, Attorney Karen, that maybe the accused was deprived of the opportunity to challenge it. Well, again, you see, in the Philippines, we are so used, we are quite familiar with the process where the criminal charge begins with the complaint affidavit of the victim. Mm-hmm. And in the court, in the ICC, that is not the norm. It is the prosecutor who initiates the charge. In other words, the victims technically are not complainants. They are just victims for that purpose. The charges are filed by the prosecutor, and that is why the case title here is Prosecutor versus Rodrigo Roa Duterte.
Yeah, I noticed that's something that's also different because normally you have Republic of the Philippines versus and then the name of the accused. Or in the US, it's the United States versus and then you have the accused again. So here it's really the prosecutor.
Yes. Karen, again, as I'm sure you've seen, you've been taught in Balcom Hall, it is litigated in the name of the people because theoretically the people are the injured party.
Yes. Yeah.
And it is the assault is upon our communal collective interest as a people. It is an assault upon the moral integrity of our community. It is an assault on the norms that bind us together as a community, and therefore it is people versus the accused.
Yes.
Well, I guess, Karen, this is the thing about these new international criminal tribunals. They had to invent something. And I guess calling it prosecutor versus the accused was the closest equivalent. Otherwise, they would have, if you're consistent with that logic, the ICC vindicates the communal sense of justice of humanity. So maybe it should have been entitled, the human race versus Rodrigo Roa Duterte, or I don't know, humanity versus.
And Judge Raul, on that note, there have been mass actions in the Philippines and abroad, and even some people writing to the ICC to bring former President Duterte back home. Will any of these have any bearing in the ICC proceedings or the judges handling the case? But before you answer that question, we'll have to take a short break. At the Forefront, we'll be right back. Welcome back at the Forefront. Judge Raul, there have been mass gatherings all over the Philippines and even abroad, and then even some Filipinos writing to the ICC to bring former President Duterte back home. Will any of these have any bearing on the ICC proceedings or the judges handling the case?
Okay, I have to be careful answering this, Karen. I don't want to be giving signals either way that might affect the judgment. But for me, the safest answer, Karen, is that the principle is that the judges have to try to be insulated from any of the political events outside the courtroom. In fact, even if, let us say, an accused starts or a witness starts misbehaving in the courtroom, they immediately try to remove us from the room so that we don't have to witness any of the mess happening. Because again, the theory is that the judges must form their decision on the guilt or innocence of the accused solely on the basis of what is presented in the record and in the courtroom. Okay. I think that is the fundamental principle governing the exposure of the judges to all these tumult happening outside.
Okay. And Judge Raul, does the ICC also consider procedural matters? So you have mentioned that they will determine the guilt or innocence of the accused based on the evidence presented in court. But what about procedural matters? So for example, would they consider the fact that a private jet was used to take the former president to The Hague, whereas from what we understand, the normal proceeding would be for a commercial flight to be arranged and someone from the ICC to accompany or escort the accused to The Hague?
Karen, as I said in my lecture at UP, in my experience, the ICC is completely indifferent to the way the prisoner, the accused, is brought to The Hague. The chief concern, and this is, as I explained in my long lecture, in the history of international criminal tribunals, whether it is the Adolf Eichmann case in Israel, or there was a kidnapping in Mexico that I also discussed. The only question of the court is whether the court has acquired jurisdiction over the person of the accused. And if it has, then the court proceeds to trial. That is the fundamental principle. No questions on how he got there. Okay. So in fact, this all this hand-wringing over whether it was a private jet or a commercial jet, and if it's a private jet, it had to get all these permissions for overflight in the flight path, etc. Well, in my experience in the court, we have never bothered with this minutiae.
Okay. And Judge Raul, I'm going to ask questions also as a lawyer, because some of the things, of course, as a lawyer, you tend to think of doctrines that we're used to. So does the ICC, like courts in the Philippines or even in U.S. courts, take judicial cognizance, or what we call judicial notice, of certain matters? So, for example, in this case, when it comes to the issue of jurisdiction, will it take judicial notice of the past submissions of the Office of the Solicitor General, saying that ICC has no jurisdiction and the Philippines has already withdrawn from the ICC, and then even the DOJ Secretary's speech at the UN Human Rights Council back in 2023, saying that we have a functioning court or judicial system in the Philippines, therefore the ICC does not satisfy the complementarity test and therefore has no jurisdiction. And then even our current president, President Bongbong Marcos' statements in interviews before, where he said that the ICC can come in as tourists, but they have no jurisdiction here. Or even in his press conference when former President Duterte was arrested, he said that they remain firm that the ICC has no jurisdiction, but what they did was to cooperate with the Interpol. So normally these are things that can be taken judicial notice of. Is that something that applies to the ICC?
Okay, let me answer on 2 points, Attorney Karen. I'm so glad you raised the question of judicial notice. Yes, under the rules of procedure of the court, we have the court has the power to accept as proof, take judicial notice of certain facts without need of proof. Similar to Philippine law, similar to those that you, Attorney Karen, are familiar with as a lawyer. And now to the second point. I mean, of course, all those statements that you mentioned can be entered into the record of the court via the judicial notice rule, but whether they have any bearing on jurisdiction, for me, if you ask me, they have zero bearing. Because jurisdiction is a matter of law. It is not vested upon the court by agreement of the parties. It is not lost by collusion among the parties. Either it's there or it's not there. Whatever statements were made by whoever else was sitting in some podium or in some position on the Philippines, well, for me are interesting for the court to hear, but I don't think it will determine the court's jurisdiction. So it's not as if it's loss of jurisdiction by default, or loss of jurisdiction by sort of a declaration against interest. No such thing. So, but again, Attorney Karen, I'm pretty sure all these statements will be brought to the fore by a defense counsel who wish to challenge the decision of the court. And but again, my sense is that the court will decide jurisdiction on the basis of its own rules.
Okay, and Judge Raul, how long do you think this can take? A lot of people are saying on average 10 years, but one of the interesting cases that I came across was Jean-Pierre Bemba of Congo, where it took 8 years for him to await trial. He was held in custody or incarcerated at that time by the ICC while waiting for the verdict. And then after 2 years since the verdict, this was overturned. He was acquitted eventually on appeal. Is this something that would also apply to former President Duterte's case, like an average of 10 years? And then would he have also the opportunity to appeal should he be convicted?
Well, Attorney Karen, first of all, I'm so glad you reminded me of the Bemba case. Bemba, it is actually the Bemba case that I was referring to earlier. He was convicted by the trial chamber consisting of 3 women, he was convicted of several counts of sexual offenses. And that was the poetic justice that critics mentioned at that time. And you're correct, Attorney Karen, it was a landmark reversal and acquittal on appeal after a full trial on the merits. Well, okay. Now the question of whether this case will last, the prosecutor versus Duterte, will last 10 years, I don't think so. Because you see, in Bemba et al., there were so many charges, so many counts. In the last case that I heard, we had 75 counts, and then there were 9 crimes charged, and it lasted, the pure trial on the merits, 3 years from beginning to end. So compare that with, and by the way, that's the trial phase. I'm not talking about the pre-trial phase. Again, that depends on defense counsel if they want to prolong the pre-trial phase with all sorts of procedural issues. But let me just raise one point. Why I think that the prosecutor versus Duterte, if it does proceed to trial, will be much shorter. Attorney Karen, there's only 1 crime charged, murder. In contrast to those other cases where there are like nine crimes, charged. So
you think it would be shorter, definitely?
You mentioned earlier, Attorney Karen, that he was linked to the crime as an indirect co-perpetrator. So that means he was aiding and abetting the commission of the offense. So for that, I don't know, maybe they should just, well, exactly along the lines of what you said earlier, they could just rely on all the speeches that he delivered.
Okay. And unfortunately, Judge Raul, we're out of time. I wish we can have you guest again, especially when you're back in the Philippines. But I had more questions, but we ran out of time. Ang bilis po ng oras. Thank you again, Judge Raul Pangalangan, and it was a pleasure to have you here live all the way from Washington, D.C.
Well, Attorney Karen, thank you so much. Congratulations on your continuing success. I'm very happy to see my students enjoying life.
Yes, and thank you. You taught me well. I was your student in public international law.
And I recommended you to Harvard.
Yes, I know. Thank you, Judge Raul. As the case of the former Philippine president unfolds, the Philippines and the world are closely watching how the ICC conducts its mandate in the face of political and legal complexities to serve international justice. Be timely informed, be insightful of the news, always stay at the forefront. Join us again tomorrow for meaningful conversations that would help you form an objective personal opinion. This is Attorney Karen Jimeno. Thank you for spending your hour with us.